So here we have another situation, and lately I've been trying to tell you guys, if you don't know the laws of your state, you need to start doing so. You need to start actively trying to learn them so you know. All right, here we have another situation of an alleged or potential illegal arrest. Let's check it out. Disclaimer first, though.
Welcome to Audit the Audit, where we sort out the who and what and the right and wrong of police interactions. This episode covers reasonable suspicion, the knock and talk doctrine, and fighting words, and is brought to us by Rob Huff's channel. Be sure to check out the description below and give them the credit that they deserve. Before we dive into the interaction, I want to give a big thanks to the sponsor of this episode. On May 13th, 2023, Deputy Hudson and another officer with the Sussex County Sheriff's Office pulled over local landowner Robert Huffman as he was driving near property he owned in Sussex County, Virginia. Mr. Huffman began to film the encounter shortly after he was stopped.
Hey, sir, how you doing?
We're doing fine. What's the problem?
I got a shooting range or something over there?
My property.
That's your property?
Yeah.
Okay, so people currently shooting over there now?
What's going on?
So we get a call of shots fired in the area. Listen, anytime shots fired in the area, you got the ID on you, sir?
I haven't committed a crime.
Right now there's an investigation going on, sir, for
Watch
shots
yourself,
fired in
please.
the area. And I need to know who I made contact with. What's your name, sir?
My name's Rob. It's a pleasure to meet you, Hudson.
Okay.
Yes, sir.
All right. So we got a call of shots fired in the area. Do you own? You say you own that land up there?
Yes, sir.
You live up there or just land?
Just land.
Anytime shots fired in the area, we got to come. If it's hunting, hunting time, we get a lot of calls. So
Okay.
we have to investigate because we don't know what's going on. So that's what I'm investigating.
So this is one thing I need to learn and do better at myself. Okay, knowing when you're in certain states whether or not you have to ID. Now, for some people, they don't care. If a cop asks them to ID themselves, they're gonna ID themselves. You know what I'm saying? I'm one of them. You ask me that, I have nothing to hide. That's the way I look at it. I have nothing to hide. So I'm gonna ID myself so I can keep going and do whatever it is I was headed to do. You know what I mean? But for some people, they don't. And if you don't, you best for sure know the rules of your state. Seriously. I've seen some people be right, and I've seen people be wrong.
A lot of calls. So we have to investigate because we don't know what's going on. So that's what I'm investigating. So again, you got your ID on you.
No, it's not illegal.
So I gotta make
I didn't break any laws.
Yeah. So we got a call of a red truck that shots fired in the area. So do
What
you
crime?
have shots fired in the area?
That's a crime?
Yes,
In
sir.
the county?
Ran the roadway and the houses in the area.
Oh,
Yes,
no,
sir.
no, it was never any.
Okay, I don't know that yet. I
that's
haven't
not
went
true.
back. The only thing I got is a red truck.
I'm just gonna exercise my Fifth Amendment right at this point.
Okay, that's fine. I need your ID though, sir.
I'm not gonna ID
right.
myself. I haven't broken the law.
Step out the vehicle for me, sir.
I don't consent to any searches or seizures.
I'm not searching vehicle. Right now, you must identify yourself, sir, because I have made contact and there's an
I haven't
ongoing
broken the
investigation.
law. I'm exercising my Fifth Amendment right.
You're refusing to identify yourself to me.
You haven't articulated a crime.
That land belongs to you.
Yes, sir.
Do you have any backstops behind any shooting that's going on back there?
I'm not going to answer any questions.
Okay, that's fine. Give me 1 second.
Can I see your supervisor?
He is a supervisor, sir.
I allow people to hunt on that property as well. So
Okay.
when they're hunting, is that a crime?
Something I've been noticing too, is that part of it, is that the next step of progression that you ask for a supervisor? The reason why I seen another video where a couple had got arrested. They were standing by their truck and an officer did the same thing and he was asking them, you know what I mean? He said there was an investigation. I'm picking up on the same lingo. So he said it was an investigation and he said he needed to ID him. The male refused. You know what I mean? He said he hadn't committed a crime, similar to what this guy is saying. He said, I haven't committed a crime, so I'm refusing. He didn't say he's exercising his Fifth Amendment rights, but he said, I'm refusing. You know what I mean? But the next step, when the officer started to actively arrest him, he started asking for a supervisor. So I'm wondering and I'm guessing, is that the next step of progression up? Is to ask for a supervisor next? You know what I mean? I'm gonna look into that. But I'm noticing certain similarities in the two videos.
How much land you got?
I'm not going to answer any questions.
I'm just going to
Because I have a Fifth Amendment to the Constitution.
You want to assert your rights. I have no problem with
I'm
that.
being
Okay.
illegally detained at this point. I have no obligation to assist you in your investigation. The Fifth
I
Amendment
just
to
want
the
to know what your
Constitution.
issue is. Why you don't want to talk to us? That's
I don't
my
like
question.
police. I'm sorry. I think
Okay.
you guys are tyrants.
Okay. Well, technically we have enough to stop you for the incident that we're investigating. And technically, if you want to get into the aspects of the law, you're just driving down the road. We have a right to see your driver's license registration. There's
No.
Supreme Court case law on that.
Yeah, if I violated the law.
Okay.
What's the law?
Okay.
RAS, reasonable articulable suspicion. If you can articulate to me reasonable articulable suspicion, I will be happy to ID myself.
If you want to play the reasonable person standard, we'll play that. I don't have to have a crime to stop you. I don't have to have a crime to ID you. I don't have to have a crime to talk to you.
You have to have a crime. If I've done something wrong, I will ID myself. You tell me what I've done wrong, and I will ID myself.
Show me where in a law book anywhere that reasonable suspicion equals a crime.
The officers argue that they have reasonable suspicion to detain Mr. Huffman because they received a call that a red truck was seen in an area where shots had been fired, and that they do not, quote-unquote, need a crime in order to have reasonable suspicion. As we've discussed before on ATA, in order to detain an individual, an officer must have reasonable, articulable suspicion that they have been, are, or are about to be engaged in criminal activity. However,
now this is scary because here you have a citizen allegedly quoting the laws better than an officer. Do we not see a problem here? Because I do. You know what I mean? And that's why I'm always wanting to watch this kind of stuff right here, because you're starting to see that some of these officers have no clue of what they're doing and what they're out here supposed to be doing. They have no idea or clue of the laws. Not all of them, but some of them do. And that's not good, because then a situation gets escalated that shouldn't be.
Does not necessarily mean that an individual must have actually broken the law or committed a crime in order for an officer to detain them. As the Supreme Court recognized in the 2000 case of Illinois versus Wardlow, a detention may be justified even if an individual's conduct is lawful, ambiguous, and susceptible of an innocent explanation if it also is suggestive of potential criminal activity, and that the infamous Terry case recognized that officers can detain individuals to resolve such ambiguities, arguing that, quote, in allowing such detentions, Terry accepts the risk that officers may stop innocent people. Therefore, a report of shots fired could serve as a basis of reasonable suspicion, even though some discharges of firearms may be legal, as shots fired could be potentially indicative of criminal activity. Nonetheless, in this situation, it is questionable whether a report that a truck was seen in an area where shots were heard would be sufficient to give the officers reasonable suspicion to pull over Mr. Huffman and detain him. In the 2011 case of U.S. versus Massenburg, the Fourth Circuit Court of Appeals, which has jurisdiction over Virginia, held that an anonymous tip that shots had been fired in a high crime area in which random gunfire was typical was insufficient to support a Terry stop when the tip contained no physical description of the perpetrators, and the only link between the tip and the detained group of citizens was their rough proximity to the alleged site of the gunfire. Now, on the other hand, in the 2010 case of U.S. versus Monroe, the Fourth Circuit concluded that an officer was justified in initiating a traffic stop based on the similar broadcasted description of a vehicle that was suspected as being involved in a nearby robbery that had occurred a few minutes earlier. Additionally, in the 2021 case of McCormick versus Kershaw County Sheriff's Office, the U.S. District Court for the District of South Carolina noted that although at least one other circuit had determined that the fact that a vehicle matched the general make and color description of a vehicle involved in nearby criminal activity was insufficient to establish reasonable suspicion, there was no controlling authority in the Fourth Circuit that clearly established such a rule. In this situation, the officers had a description of Mr. Huffman's vehicle, but it was only reported as being in the vicinity of where the shots fired were heard, which in a rural neighborhood where hunting is common is not particularly strong evidence supporting a reasonable suspicion that its driver was involved in criminal activity.
And remember, the officer said, we get those kind of calls all the time. So to me, that red vehicle in the area, that kind of, when you say that, it kind of diminishes this stop. It brings it down. Like, you really, like, it's in favor of what the citizen is saying. I haven't committed a crime. I haven't done this. You tell me what I've done wrong. I'll gladly ID myself, but I'm exercising my Fifth Amendment rights. It's leaning more towards him, with the officer saying that it's hunting around here all the time. Then he told him he has property up here as well. Like, yeah, it's not looking good.
Without more information about the nature of the tip, such as if it was anonymous, it is challenging to predict whether a court would determine that the officers had reasonable suspicion to stop Mr. Huffman. But Mr. Huffman would certainly have an argument that the stop was not constitutional.
Is this Terry v. Ohio? Is this a Terry stop?
No, I don't think it's a Terry
There
stop.
you go.
Okay.
Am I free to leave?
You can't shoot within a certain feet of the homes. So if you are in violation of that, you will be charged. Okay?
There's still no crime.
Yes, it is a crime. You can't shoot within 30 feet of a home,
So
sir.
how many feet was that in?
You're good to go, sir. Have a
All
good
right,
day.
thank you. Y'all take care. Stay safe.
After the officers allow Mr. Huffman to leave the traffic stop, they drive onto Mr. Huffman's nearby property, exit the vehicle, and approach his father, Michael Huffman, who was on the property with Mr. Huffman's permission. The exchange that followed was captured on Deputy Hudson's body camera.
So whoa. So this kept going. Whoa. Yeah, this not gonna be good already. They're already, like, they should have got some new officers out here, especially if they walk up and see or once they figure out that it's this guy who they just recently stopped's father. Like, you're gonna need some fresh officers on the scene.
How you doing? My name is Deputy Hudson with the Sussex Sheriff Department. Listen, sir. My name is Deputy Hudson with the Sussex Sheriff Department, sir. We got a complaint from a neighbor right here, and right here.
Get over it. We're out here. We're 200 yards from anything near us, and we're firing into the ground.
You gonna let me talk, or you gonna finish?
I'm gonna finish. You are trespassing. You are not allowed on this property. The gate was closed.
Oh,
Sir, you got your ID on you?
I don't have to give you ID. The Constitution says I don't have to give you an ID unless I have broken a law.
Do y'all own this residence right here, sir?
Yes.
Who owns it?
My son and I own it.
Okay, what's your name?
Again,
I don't know if you trespass or not. What's your name, sir?
my name is.
Your son's on it.
Our family own it.
Okay, so did he give you permission to come out here? Did he give you permission to be out here?
Yes, he has, but I have permission. You don't get to my property.
So he gave you permission to be out here, sir?
Yes.
Be
Did
out
you
here,
or
sir.
did you not pull
Sir,
him
did
over?
he
Not
give
5
permission?
minutes
No,
ago.
he didn't identify himself. I don't know who he is. Did he give you permission to be out here, sir?
I have permission to be
Can
on
you
my
call-
own property.
Can you call and verify that he gave you permission?
And I've been telling him the same thing. To
So
get
who's
fuck
the
off
owner of the property?
He is.
What's
Get
his
the
name?
fuck off my property.
What's his name, sir?
Get the fuck off my property.
You have.
now here's the problem. This is what I've been saying, bro. Like, we got to get to a point to where we can communicate. Pops is hot. He is mad. He is upset, and I understand why he is. You know what I mean? I'm out here doing something. I'm on my property. I don't know if he's getting complaints because of the noise or the shots fired from the neighbors or whatever like that. You know what I mean? So he thinks he's doing nothing wrong. He's on his property. He's abiding by the law, according to him. You know what I mean? Cop pulls up. He automatically gets upset. You know what I mean? And they can't even communicate at this point. Like, there is no, Pops he don't walk back and forth to that truck so many times. He don't walk by almost a rut in the ground. Like, he's hot. He's upset. They breaking down the stuff where they was doing it. And you can tell it's building and building and building. So this is now going to turn into the officer is really going to have to figure out how to calm him down. He's going to have to pretty much turn into a negotiator at this point.
Have your ID on you, sir? So we're trying to figure out who property this belongs because it looks like some abandoned property. Do you have your ID on you, sir?
I don't need an ID.
Sir, I can't leave right now because of the open investigation.
You're trespassing.
Sir, you might want to calm down before you go to jail, sir. You might want to calm down. Well, if he owns it, he needs to come back and show his ID. Okay, that's
You heard
fine.
that? Get the hell off my property.
Sir, turn around, put your hands behind your back. Turn around, put your hands behind your back for destruction and not cooperating with law enforcement.
When the elder Mr. Huffman refuses to identify himself and tells the officers to get off the property, Deputy Hudson places him under arrest for, and I'm quoting, obstruction and not cooperating with law enforcement. Virginia does not have a stop and identify statute that requires individuals who are not driving a vehicle to identify themselves to officers during Terry stops, and failing to identify does not violate Virginia's obstruction statute, which is found in section 18.2-460 of the Virginia Code. Although the statute states that, quote, if any person without just cause knowingly obstructs any law enforcement officer in the performance of his duties, he is guilty of a Class 1 misdemeanor, Virginia courts have construed the term obstructs more narrowly than some other states have. As the Court of Appeals of Virginia explained in the 1998 case of Ruckman versus Commonwealth, quote, to constitute an obstruction of an officer in the performance of his duty, it is not necessary that there be an actual or technical assault upon the officer, but...
You know, it's another issue I have. Here's another issue I have, and maybe somebody can explain it to me why. And maybe after you explain it and break it down to me, I possibly won't have this issue no more. But why can't we get each state to have similar laws? Like, you go from state to state to state to state to state, and the laws are seemingly different. You know what I'm saying? Not different in and a wide gap from Georgia to Florida or Virginia, but there is some huge discrepancies and differences between states about what you can and cannot, what you have to prove or provide, and what you have to do in different things in situations like that. Why can't we get on one accord? That way, if I go to Florida, I know the laws of Florida. They're the same as in Georgia, or the same as in Texas, or the same as in California, or New York, New Jersey, et cetera, et cetera. Is there a reason for that? Somebody please explain and break that down to me. And it could be rudimentary and I could just be that slow and just don't know the reason. That's fine with me. And maybe once you explain it, I'll be like, okay, cool. I understand that. I can walk away better knowing that. I'm a better person at that point. But somebody explain that to me. Why they gotta be so different?
There must be acts clearly indicating an intention on the part of the accused to prevent the officer from performing his duty, as to obstruct ordinarily implies opposition or resistance by direct action. It means to obstruct the officer himself, not merely to oppose or impede the process with which the officer is armed. Further, the court also noted that, now quoting again, there is a broad distinction between avoidance and resistance or opposition, and that, quote, obstruction of justice does not occur when a person fails to cooperate fully with an officer, or when the person's conduct merely renders the officer's task more difficult, but does not impede or prevent the officer from performing that task. Based in part on this precedent, the Attorney General of Virginia concluded in Official Opinion 02.082, issued on October 10, 2002, that, quote, a law enforcement officer, even when armed with reasonable suspicion that criminal activity may be occurring, may not arrest a suspect for obstruction of justice on the basis that the suspect refuses to identify himself. Therefore, it is highly likely that a court would conclude that Mr. Huffman could not be legally arrested for refusing to identify himself or, quote-unquote, cooperate with the officer's investigation.
This is my question, Mr. Huffman. Are you ready to talk yet?
About what?
The property. This is the thing.
Like I said, my son's wife was raised in that trailer
And
right there
listen,
all of her life.
So
I tried to explain it to him.
Did you give me your ID? We had to basically go through this whole process. So check this out. Somebody comes out here and shoot on your property, right? I come out here and say, hey, why are you shooting out here? This is my property. I let them go. You call the police and say, hey, somebody was shooting out there. Guess what? I don't have their ID. I don't have their information. So now I'm not able to identify that it was on your property.
Whatever happened to you not trespassing on the property?
We got a call and we have to follow through. So that gives us our suit to arrive on the property.
So you can cross gates and you can go...
Yes, sir. An investigation. Yes, sir.
I did not know that.
Deputy Hudson claims that the officers were permitted to open the gate to enter Mr. Huffman's property because they were engaged in an investigation. The Fourth Amendment prohibits officers from conducting unreasonable searches of private property. However, while officers are not always within their authority to open gates, there are a variety of situations where courts have determined that officers did not violate the Fourth Amendment by opening a gate and entering private property without a warrant. For instance, in the 1984 case of Oliver versus United States, the Supreme Court concluded that narcotics agents did not violate the Fourth Amendment, or even conduct a Fourth Amendment search, when they walked around a locked gate with a no trespassing sign to enter a quote-unquote open field, arguing that, now quoting, because fences or no trespassing signs do not effectively bar the public from viewing open fields, the asserted expectation of privacy in open fields is not one that society recognizes as reasonable. The court also determined that whether or not the officer's actions would be considered trespassing was not dispositive in the analysis, because, now quoting, the law of trespass forbids intrusions upon land that the Fourth Amendment would not prescribe. For trespass law extends to instances where the exercise of the right to exclude vindicates no legitimate privacy interest. On the other hand, as the Supreme Court explained in the 1987 case of United States versus Dunn, the Fourth Amendment does protect so-called curtilage, which is the area immediately surrounding the home. In the Dunn case, the court identified 4 factors that courts should use to decide whether property is part of the curtilage of a home or an open field. Now quoting, the proximity of the area to the home, whether the area is within an enclosure surrounding the home, the nature and uses to which the area is put, and the steps taken by the resident to protect the area from observation by passers-by. In this situation, it seems more likely that a court would find that the driveway was curtilage rather than an open field, given the fact that it was enclosed with a gate and appeared to be fairly close to the home structure, although additional additional facts could alter this analysis. However, even if a court concluded that the officers entered onto curtilage, it could still determine that they did not violate the Fourth Amendment under the so-called knock and talk doctrine, which permits officers to enter the curtilage of a home to knock on an individual's door or attempt to speak with a resident without a warrant. As the Supreme Court explained in the 2013 case of Florida versus Jardines, quote, "The knocker on the front door is treated as an invitation or license to attempt an entry, and," now quoting again, "this implicit license typically permits the visitor to approach the home by the front path, knock promptly, wait briefly to be received, and then, absent invitation to linger longer, leave. Thus, a police officer not armed with a warrant may approach a home and knock, precisely because that is no more than any private citizen might do. Although it may seem that this implicit license would not extend to opening a gate to enter enclosed property, as the U.S. District Court for the Western District of Virginia noted in the 2013 case of U.S. versus Jones, quote, "The Fourth Circuit has made it exceedingly difficult for a homeowner to withdraw the implicit consent which underpins the knock and talk rule. In support of this contention, the court cited the 2004 case of Edens versus Kennedy, where the Fourth Circuit held that, quote, if the owner of a home encloses the curtilage with a fence, locks the gate, and posts no trespassing signs, the effect for Fourth Amendment purposes is to extend the walls of the home to the edge of the curtilage. Therefore, unless the gate was locked and no trespassing signs were posted, it seems likely that a court would conclude that the officers did not violate the Fourth Amendment by opening the gate to enter the property and speak with Mr. Huffman."
You're trespassing. I want you off my property.
You the owner of this property?
I'm not answering any questions.
Okay, sir. Well, I don't know if you're the owner of the property. Please step back away from me, sir.
Trespassing.
Are you the owner of this property?
You're the only one.
Are you the owner of this property,
I'm
sir?
not answering any of your
Okay, that's fine.
Oh, so you're gonna arrest my father?
Do you have your ID on you, sir?
I'm not answering any.
Okay, well, I'm gonna ask you to leave, sir, if you're not the owner of this property.
Okay, I'm the owner of the property.
Okay, then do you have your ID so I can identify that you're the owner of the property?
No. How are you gonna kick me off my property?
Because you're not identifying yourself that you're the owner of this property. That's fine, sir.
I don't have
So I'm gonna ask
to.
you to get in your truck and leave, sir.
No, I'm asking you to leave.
Are
I'm not
you the
answering any
owner of the
questions. I wanna
property?
see your
So at this time, sir, if you're not willing to identify yourself, I'm gonna ask you.
This is insane. Insane that we're doing this. We're sitting over here arguing about, and I know to some this is, but I'm just saying it pertains of all the robberies. I live in a city where there's robberies, there's crimes are being committed constantly. There's this, that, and the third going on. Manpower shortages. It's not that many police officers. Definitely not that many good ones, and they're needed. This right here seems so small to me, but to some they're saying, and I get their argument, that the police officers don't know, or they feel as though the police officers don't know the laws, and they do this to reinforce or to teach or to, you know what I mean, show that there's more training to be had in these police departments. I get that wholeheartedly, but man, this is just seeing this. I'm like, can we just get through this, please?
You to leave, sir.
Hudson.
Okay, turn around, put your hands behind your back, sir. Thank you.
I want to see your supervisor.
Right now, you're being detained, sir.
For
So we can identify
trespassing?
you, sir. No, I'm
For
not.
trespassing?
No, sir.
So
Why
how
we got
about-
him?
Are you?
Do you have any weapons on you?
Yes, I do.
What
I
you
have a 9mm Glock on my right side.
Okay. I'm going to.
Why
Is
don't
it one
you
in the
not
head?
muzzle flash?
Is it one in the head?
Come here and videotape these guys.
Stand right here, sir. And stop.
Lean against the car for me, please,
Stand
sir.
right here, sir.
Stand right there and relax, okay?
Don't you fucking pointed that gun at me.
Sir, stop cursing at me
It's
before you receive a charge.
I have the freedom of speech.
No, you
okay?
don't.
I don't have the freedom of speech on my property. Video record this, Alec, Jared.
You got anything on you that's gonna poke me, stick me, or hurt me, sir?
Yeah, I got these nuts in your mouth. You
5'8".
pointed a gun at me, you dumb.
What's the name?
These nuts in your mouth, fat boy. Y'all's, I'm gonna get y'all's fucking numbers too. Is that thing on?
Is it your property?
Yes.
You got anything to prove it is your property?
My wife sent me the deed on my phone that you confiscated without a warrant.
No, I don't.
Oh, you think it's funny? You see, you guys are lowlifes, man, and you're proud of yourself. Didn't you swear an oath to the Constitution?
All right, so you have a right to remain silent. Anything you say will it can be used against you.
So, Mr. Huffman, if we could just establish that the property's yours, and if you can do that easily by showing us the deed on your phone, that would greatly help our situation out.
So do you have that?
Yeah, I have it on your phone. The one that you took from me, Hudson.
Investigative detention, and we'll do what we have to do, okay? All we're looking for is a little compliance. That's all,
You don't
please,
get
sir.
any compliance.
Do you have the deed and
I'll
you
show
willing to
you
show
the
us it?
fucking deed, Hudson, you low-life piece of shit.
This time, sir, You're going to be charged.
You're going to charge me with trespassing on my own property?
No, I'm charging you for your verbal abuse.
Oh,
and your
that's the
profane
First
language
Amendment
use.
to the Constitution.
No.
I'm on my property. The first, are you aware? Are you familiar?
Sir,
with
listen, sir, let's cut
You
it
don't know
short.
the
There's
First
nothing else to say,
Amendment?
sir.
This is nuts, man. Oh my goodness, fam. This is why I can't be a police officer. This is exactly why I cannot be a police officer, man. This is like, oh my gosh. The officers may be in the wrong. The citizen ain't making it no better. We act like children. We can't even have a simple conversation. We can't even, like, this is nuts to see, man. And the back and forth is just absolutely not called for.
Turn around right here,
That's
sir,
the
and
first-
just wait till a supervisor
That's
get
the
here.
First Amendment. It's freedom of speech.
Sir,
I can say anything I want.
You're right.
You
You're
just
right.
said you're arresting me
You're right, sir.
for using foul language.
You're right, sir.
When Mr. Huffman directs a profanity at Deputy Hudson, he informs Mr. Huffman that he's going to charge him for his quote-unquote verbal abuse. Section 18.2-416 of the Virginia Code states that, quote, if any person shall, in the presence or hearing of another, curse or abuse such other person, or use any violent abusive language to such person concerning himself or any of his relations, or otherwise use such language under circumstances reasonably calculated to provoke a breach of the peace, he shall be guilty of a Class 3 misdemeanor. However, in the 1973 case of Mercer versus Winston, in order to ensure that prosecutions under this statute did not violate the U.S. Constitution, the Supreme Court of Virginia limited its application to so-called fighting words, or, now quoting, words that have a direct tendency to cause acts of violence by the person to whom individually the remark is addressed, as this category of speech is not considered to be protected by the First Amendment. For this reason, the Fourth Circuit Court of Appeals concluded in the 2021 case of U.S. versus Bartow that an individual could not be convicted of violating this statute for using a racial slur when the government did not prove that the individuals to which the slur was directed actually responded violently, or that
He told him, he invited him to his manhood, basically. He pretty much did, like, he called, like, all of that type of stuff. That's why I say, like, you could be in the right. Everything that guy, the citizen, said could have been in the right. And then you start going a little bit too far and you take yourself in the wrong. We sometimes we just don't know how to be right. We got to try to just go all the way. You know what I mean? Like, bruh, it wasn't even, you might have won this situation. Now it's going to be back and forth now. Like, a judge may get mad at you, get mad at the officer, and throw the whole thing out. Then you're right back to square one. I don't know.
a reasonable person in their positions would have done so, despite acknowledging that, quote, the ugly racial epithet used undoubtedly constituted extremely abusive language. Additionally, it is important to note that Mr. Huffman's allegedly abusive language was directed at a law enforcement officer. And as we have discussed before here on ATA, the Supreme Court explained in the 1987 case of Houston versus Hill that, quote, the First Amendment protects a significant amount of verbal criticism and challenge directed at police officers, and that it is, now quoting again, protected against censorship or punishment, unless shown likely to produce a clear and present danger of a serious substantive evil that rises far above public inconvenience, annoyance, or unrest. In the Hill case, the court also favorably cited Justice Powell's concurring opinion in the 1974 case of Lewis versus City of New Orleans, where he, now quoting, suggested that even the fighting words exception might require a narrower application in cases involving words addressed to a police officer, because a properly trained officer may reasonably be expected to exercise a higher degree of restraint than the average.
Now, I do agree with that. Officers, you chose this job. So, you know what I mean? You got to be able to have a shield in front of you that keeps you calm and lets this stuff bounce off of you. You signed up for this, so you got to exercise a level of patience.
Citizen, and thus be less likely to respond belligerently to fighting words. Applying these principles, the Court of Appeals of Virginia held in the 2000 case of Martilla versus City of Lynchburg that an individual could not be convicted for using abusive language against police officers when he directed derogatory and profanity-ridden insults at them, concluding that the evidence was insufficient to prove that these statements, now quoting, had a direct tendency to provoke an immediate breach of the peace by reasonably trained police officers in the position of of the officers to whom the remarks were addressed. In support of its decision, the court argued that, quote, "This is precisely the type of verbal criticism of police officers that is protected against censorship or punishment by the First Amendment, because it is not, under the circumstances established by the record, likely to produce a clear and present danger of a serious substantive evil that rises far above public inconvenience, annoyance, or unrest." Accordingly, it is highly probable that a court would conclude that Mr. Huffman could not be convicted of a violation of abusive language for his speech, as a well-trained police officer would not be incited to violence by his use of profanity or his insults. And
there you have it. So the citizen could possibly potentially be in the right in this situation as well. You know what I mean? Which is, I mean, you know what I mean? That's why I'm not an officer, because, yeah, I've been wanting to arrest him too as soon as you start talking to me like that. So that's why I'm not an officer.
And Deputy Hudson did not appear to be actually physically provoked by his language.
Bobby, shut up. He's just jumping at straws to have some way to be a big man.
Yes, sir. Okay. Where's the name, man? All right, we're going to finish this up and they'll be on their way. She showed us the deed. Get this paperwork. No, I'm not I'm got to,
You're going to violate his right
stroke and stuff. Cool. I'm charging him, though.
Okay. Why are you charging him?
All right, so this is what we can do, sir. I can stroke you a summons and let you go, or you continue to talk. I can take you to the jail and take you in front of the magistrate.
I just want to know, I want you to write on that sentence what law I have broke. Because I have not broken any law.
After determining that Mr. Huffman was the lawful owner of the property, Deputy Hudson issued citations to both Huffmans for using abusive language in violation of Section 18.2-416 of the Virginia Code. As of the date of writing this episode, both charges are still pending. It is unclear whether the Huffmans have filed a complaint or intend to pursue legal action for any violations that occurred during this encounter. Overall, Deputy Hudson and the other Sussex County officer get an F for maintaining a hostile and confrontational demeanor throughout the encounter, repeatedly exceeding the bounds of their legal authority, and arresting the Huffmans for conduct that Virginia law has made unambiguously clear is not illegal. Although Deputy Hudson eventually cited the elder Mr. Huffman for using abusive language, he originally informed him that he had been placed under arrest for obstruction and refusing to cooperate with law enforcement, despite clear Virginia precedent and an opinion from the Virginia Attorney General stating that individuals cannot be arrested for refusing to identify, and that obstruction requires more than a failure to cooperate with law enforcement. Deputy Hudson also chose to arrest the younger Mr. Huffman for his speech, which, albeit offensive, did not rise to the level of unprotected fighting words, and posed no danger to society, beyond potentially inflicting a light bruising to Deputy Hudson's self-esteem. Throughout this interaction, Deputy Hudson chose to prioritize his own ego over the requirements of the Constitution, and likely violated the Huffman's rights in the process. The Huffmans get an A-, because although they demonstrated some level of confusion regarding the legal contours surrounding reasonable suspicion and when officers may enter property, they firmly asserted their constitutional rights and confronted the officers for their blatant disregard for the First Amendment. While the Huffmans certainly could have chosen to use less colorful language to express their distaste for the officers' actions, they were well within their constitutional rights and engaging in protected speech throughout the encounter. And I commend Mr. Huffman for sharing this interaction on his YouTube channel, and for encouraging his viewers to contact the Sussex County Sheriff's Office to express their disagreement with the officer's actions. Let us know.
So that's the end of the video, man. This is my thing, right? And this is my takeaway from this, because each time I watch one of these videos, I learn something. I learn something more. You know what I mean? My takeaway from this is, man, I think officers need to be highly trained in like negotiations. You know, like hostage negotiations. If you notice your negotiators, they're very calm. They're well trained in talking someone down. A lot of the times I see the officers talking at the person instead of trying to, it's like they're inserting their, you know what I mean? Who they are, their stature, their position over a citizen, you know what I mean? Instead of trying to talk them down. If you got an irate belligerent, you gotta have enough patience to sit there and know how to calm the situation. Is what I'm thinking. They should be trained in like hostage negotiations before they're released on the street. That was my takeaway from this video. and a few videos I've seen recently, they don't know how to talk someone down. And it don't even seem like they try. It's almost like I have a badge, I'm the officer, you either shut up or listen, or you go to jail. And that's it. So it ultimately always leads in the situation getting worse. But y'all get at me in the comment section, man. Let me know what you thought of this video. And stick around. Stay tuned. Till next one, I'm gone.